Welcome back, everybody. I'm David Graham. I'm a litigator and regulatory lawyer, and I was tasked with talking about the Loper decision. I want you to you can put my slides up if you want. Nate's might be more useful, actually, because I'm trying to apply this decision to due diligence. And so it's a layer of analysis that I think, a high level layer of analysis to evaluation of companies, both by a target if you're trying to get ready to be sold, or if you're a purchaser, because there's a new dynamic with, so we've had 40 years of, if a regulatory agency says something and makes an interpretation of a statute, and that's an ambiguous statute, uh, that's the way it is, right? And the judges are told not to disturb that. Well, that's different now. We don't know exactly what's going to happen. I couldn't find a decision citing Loper yet. That's how new it is. So I unfortunately can't use up my time with war stories because there are none. And there's just wars to be fought. So next year, this would be a different interpretation based on a circuit's or a district court's decisions about fights over agency interpretations of statutes that individual companies might make, or consumer advocates or other groups that have an interest in our regulated or government regulation. So with that preface, then I am going to suggest that when you're entering a transaction, there is a layer of analysis that you can apply um, that we didn't have before, last 40 years. It's not that nobody did it, but what is it about this company, whether it's yours or one you're looking at, that might lend itself to um, less limitations on what it does, because things that that company might not have done in terms of expanding their market or how they marketed their products or the finances, how they were set up or how they interact with patients, how they advertise, might not be limited as much as before. So maybe it's a point of opportunity. One thing I will preface that the Loper decision will not impact is what Amanda talked about. If you're doing things illegally, most likely challenging the FDA's interpretation of a statute after the fact is not going to change um, how the DOJ looks at what you did and whether you'll be prosecuted or not prosecuted or whatever happens. So this is not a discussion about criminal or other liability under um, the various anti-fraud statutes. I just wouldn't look at it at that way at all. Someday there will be a fight. The DOJ has to fight about that. And there was a little bit in the Trump case, right? So they changed their prosecutorial stance in the case relating to January 6th because of the decision. But I wouldn't, in the FDA context particularly, um, look at that as a panacea or some way to mitigate liability. Could be someday, but that's not what this is about. So we'll have to think about that later. Um, so what are the objectives? Well, one is to understand the Loper decision. Well, first of all, the Chevron decision that it replaced, then talk about the Loper decision and what it means and why we have it, and then go on to try to drill down a little bit about how it might affect FDA regulated company transactions. So that's basically the outline of the presentation. And so let's proceed there. So the Loper decision overturned Chevron deference doctrine. So this is a constitution, constitutional separation of powers resetting by this Supreme Court. And that's going to happen, has been happening with this court and will happen in the future. And the resetting is a limitation of the executive branch in favor of the judicial branch. So what the court said in its largest interpretation is that the executive branch is exerting too much power when it has an expansive and unsupported interpretation of ambiguous statutes. And so that's generally what's going on. So a Supreme Court justice isn't necessarily, well, he's thinking about the particular facts of the Loper case, but they're also thinking about, excuse me, they're also thinking about what's the general balance of power between the branches of government. So believe it or not, that will become apparent in what I'm going to talk about related to M&A transactions. So before there was deference to agencies, like I said, the assumption was the agencies have knowledge and experience, right? And they generally do. They deal with this stuff every day. There's expansive groups of people, FDA, EPA, FTC, SEC, that have to deal with these problems every day. And we should listen to what they say and rely on their interpretations of statutes. And agencies will do better than judges, because judges will have a case that comes up and all of a sudden they have to be an expert on some environmental problem or some FDA technology or some financial scheme related to SEC regulations or something like that. So why would we rely on the judges to interpret the statute when the agency has already done so? What the belief, I believe, by the court is it has left us with agencies applying, oh, sorry, no, oh yeah, sorry, thanks. I was told to take cues about when I'm forgetting to advance the slide because I always do. So what has happened is that the belief is there's been an expansion of jurisdiction by agencies with less and less evidence as time has gone by to support. So less evidence, greater distance from the original intent of the statute. And so that's part of why the decision was made and rendered. So what happened? So the judges decided to overturn the premise that the agency's interpretation of ambiguous statutes is to be deferred to by judges. The court said no. Judges' jobs, by virtue of the Constitution, is to interpret statutes, right? And decide if they're constitutional enough. That's a premise not only in the Constitution, but the Administrative Procedures Act. And so that's why we think now we have to go back to what the law was before 40 years ago. They did not, however, eliminate all decisions made in the past based on that assumption or on the Chevron doctrine. So don't think you can go back and suddenly unleash technologies and opportunities by challenging previous decisions made in the courts. And agency decisions are still important if to the extent it rests on factual premises within the agency's expertise. So that is to say that the agency's interpretation of statutes have to be based on evidence. So I'll keep using the word evidence when I'm a litigator. Two, it applies to what Nate was talking about, right? So all our businesses are based on evidence, scientific evidence and clinical trials and other things to prove that we have efficacy and safety. And so, so there has to be evidence supporting the FDA interpretations, specific evidence related to the specific issue at hand, not just sort of generally, well, we deal with this a lot and in our experience, it's been blah, 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 but it has to be more targeted. So that deference has to be specifically related to the facts of the case. So that's the new sort of, I mean, there's a lot more to the decision, but I wanted to try to distill it for you so we could sort of have a broader understanding of what we're dealing with. So what's the impact on the FDA? Well, most people think that the normal do gather evidence, send it to the FDA, prove that your advice is efficacious and safe is not changing. It's so specific. So I want you to compare what we do, right, in terms of that process with determining whether a particular uh, pollutant or something else will cause damage 40 years from now in climate change, right? So there's a big difference between having done clinical trials carefully and, for a particular disease process with a particular device or drug than making speculation about what might happen in the future, either in the ecological world or the financial world or something like that. So a lot of people think that the FDA, plus the FDA is a black box to the lot of the world, right? Including presidents of the United States, right? Senators, Congress people, right? It's so technical and that, and people are afraid to interrupt something that might negatively impact their safety. So if they really know what they're doing, they have doctors checking on what they're doing, why are we going to interrupt that? This will probably not affect food, the world of food and veterinary medicine. But the FDA will receive more challenges. So that gets us now to how we might analyze transactions. Already Congress sent to the FDA and EPA hundreds, if not thousands, of subpoenas for documents. They're thinking that they're going to go back and show the world and all the decisions made interpreting statutes that were wrong, upon which rules are being made that are improper, that are impacting industry or their constituents in a particular area of the country. And so the challenges have already started. I don't know. I mean, I wouldn't have a way to know if that's happening in court context, right, yet, since it's so new. But there now is an avenue to say to a court somewhere that, the FDA's rule that impacts my business was made on this interpretation of the statute. We think that interpretation's flawed or beyond their jurisdiction or whatever malady it might have. In court, we want you to correct that, which allows me to do X, right? Use this medical product for A instead of just B and C, or I should say B and C instead of just A, or something like that. So people will be seeking specific opportunities to target technology that they deem is bottled up, or marketing opportunities by FDA rulemaking or SEC or FTC or whatever else might impact our businesses, including environmental practices, and we'll proceed that way. It also may slow down decisions. Now, in the world of healthcare, meaning broadly, your products that help people get better, there will always be the counter pressure, right? No, don't get in the FDA's way, right? Of things that we've been trying to speed up for decades, right? What's always been the challenge, right? So upon this discussion is the reality that FDA's work with food and medical devices and drugs is, people are afraid of slowing it down. So there'll be always constituencies, diabetes association, heart association, other things that will be putting constant pressure on to not allow this change of paradigm to impact the development of technology that can be life-saving, life-improving, and whatever else. All the other good things that the med tech industry does for people. I wanted to, before we go on to more specifics of due diligence, there's other things that impact transactions, right? When you're looking at a target, there may be rules related to how it's financed. If you're a venture capitalist, right? What do I got to do? What is the SEC saying about what I got to do to inform people about things and put in disclosures and things like that? Now, there's a difference, obviously, between publicly traded and private business. I understand that. But there'll be challenges to SEC rules and FTC rules related to consumer protection and things like that that may also impact how you view a transaction. And there also may be people challenging those potential hindrances to the transaction you're trying to make that you need to keep an eye on. So in the due diligence process, it's not just how does my specific technology, how is it being impacted by FDA rules and regulations that I might think are inappropriate, but how are other things going on in antitrust, consumer protection, privacy, and other things like that, where people are making challenges that might change the value of a company, or how I structure the transaction, and things like that. So I just mentioned those because obviously the industry rubs up against a lot of different roadblocks potentially, not just those of the FDA, but other regulatory agencies that impact med tech. So I mentioned those here. So questions to ask yourself as you're approaching the transaction. And I think that, again, this is part of just taking a step back and seeing how the new landscape may benefit you. So I look at the decision as all potential opportunity, unless more challenges, which I forgot to mention at the beginning. So the assumption is that by the Supreme Court, that judges are going to make better decisions than the agency about ambiguous statutes that lead to rules that lead to. What I think they fail to get, that it's jurisdiction to jurisdiction, right? So you may get a judge in Minnesota that thinks completely differently, or California, than a judge in Texas or Alabama or somewhere else, right? I'm making assumptions I shouldn't make about those things, but so the forum shopping for judges is going to start immediately, and where you bring challenges. And a judge actually may have a more expansive and more view of FDA power or their authority, and may give more deference, right, that may not help, right, a particular technology or set of marketing rules or whatever is being challenged in the particular case. So that caveat has to be there to my otherwise Pollyannian view of this decision. It's a benefit to business. So the challenges are going to start. So you should look at, right? So part of your due diligence should be immediately to have somebody look at, this is the main set of regulations that impacts this technology. Is anybody out there challenging them right now, right? That will benefit or hurt what I'm doing, right? And not a challenge in terms of a better technology or like that, but challenging the whole premise upon which limitations are placed on it. And if they are, you might want to figure out what's the likelihood that it'll be successful. How can we help if we, right? If we if we want to, right? Are we going to be part of that challenge? Are we going to join in the case? Is it worth the money at all, right? Or should we just wait? Or is it just a benefit that, well, if it comes along, that'll be great. That's just a bonus, right? And it doesn't really impact immediately what we're doing. So, you know, whether you should, then you should look at your specific company, right? And say, what in this company has happened that would, is being restricted, first of all, by some rules of the agency that you believed are improperly made because of their interpretation of the statute. And what do we have, right? What in all the things that Nate outlined, right? So you can go back now to that PowerPoint slide. What about all those things are we been saying and have, and evidence do we have that would possibly support a challenge, right? And there, that's why your due diligence then has another gloss, right? It's not just compliance, right? It's not just Amanda, you know, protecting yourself against lawsuits because the compliance plan wasn't very good, the quality wasn't very good, the documentation, even if it was all good, the documentation's not that good. So all of which have this defensive posture, right? And it's appropriate, and you got to protect investors, and you have to do all the appropriate things there. But now I suggest that there's a new way to look at it. Whereas, how is this evidence usable for a challenge that might expand the use of the technology, for example, or how, what we say about the technology that exists, right? Regulations on off-label usage or something like that, which is always up for grabs because of the First Amendment, but there might be another challenge here otherwise. So those are questions that I think you should ask. And ask your reviewers to ask and educate them about. So you have a bunch of people, right? Whether they're in a law firm or you're their own in-house counsel or a combination, who's ever doing the due diligence to think about tactically how, if evidence is there, that would be helpful in some challenge, whether it happens now or later, or whatever, strategically, however strategically it fits into what you're doing. All right, so here's some due diligence focus areas, which I now would change this list completely. Even though I reviewed Nate's presentation first, didn't click into my head. These are the old law, right, due diligence areas, right, that really might not lead to finding evidence that might be helpful. But some of them I'll highlight. One that's not on there are the clinical studies, all what they should be, right? Are they good? Are they clean? Do they establish? What do they prove? Right? That's the most important. I mean, that's the evidence that FDA relies on at the end of the day. So compliance with laws. Right? You might view that as, oh my gosh, we've been doing this, this, and this, and our sales reps have been doing this, this, and this. And as the law stands and as the rules are, you might go, well, yeah, that's a little outside the rules, right? To what's happening. Maybe not to the extent Amanda outlined in her hypothetical, but, and then you might go, well, yeah, but you know, there's these challenges going on to how we doing things, and this set, how we do this might fit into that challenge of the existing rules, and we should see how that plays out, or at least factor that into our analysis, right? So if you're doing your due diligence report, you'd say compliance with laws. Not really, but here's what's happening in the marketplace or in the legal marketplace that might show that this is within rules that might be changed because of court decisions. All really speculative, but important consideration. Communications with the FDA and agency, obviously, really important in the analysis based on the Loper decision. So what have you been telling them, right? About, have you been pushing, right? I know that might be a dumb question because we all push, right? But people have more conservative and liberal ways. They want to push the FDA to expand how they use technology and what they can say about it. So it's important to look at that information and make sure you understand what historically the company has done to communicate about its technology and business. So inquiries, reports, notices, and court. So has the company done a good job of tracking what's going on in the marketplace? In other words, is there evidence that the FDA's interpretation of the statute's irrational? Because if you just look at what the doctors are doing with this technology, remembering that the doctors can do whatever they want, as long as you're not telling them. I mean, that's the general rule. Obviously, there's lots of shades of that. But isn't it obvious that the restriction on the use of the technology makes no sense based on what's going on in the field? And what's the communications about that? What's the record keeping about? People are afraid to keep records of what doctors are doing with their technology if it's not an approved use, right? I think that might change a little bit, right? You want to know, and it's not going to hurt you to have known, right? Because again, it's not you, as long as you're not properly promoting it. Keeping track of it and showing how good it is doesn't mean you're filling brochures in doctors' offices with all these potential uses. It does help with evidence if you want to challenge the restriction. So those are some things, well, obviously marketing documents, right? So that's, always a dangerous area, right? So you're hoping that those are not just in compliance, right? But that they're telling a story that you haven't been violating the rule willy-nilly, that would cut off any reasonable challenge, because they'll just say you're just trying to get out of liability for violating the rule, right? But if you're otherwise following the rules, then it's easier to make a challenge. So those are just some I highlight, other than Nate's list about quality and other actual scientific evidence, which will be the most helpful in any challenges that might be happening or that you might initiate. Questions?
How might challenges to FDA interpretations impact M&A volume generally?
How do they impact M&A volume? I would say very few up till now. I would say most people look at, evaluate their company and their targets, just assuming the FDA is never going to be challenged, and we have to live with that. So I would say that volume's low. Very few businesses now, and it may stay the same, right? We're talking about a world that hasn't been created yet, right? So we don't really know, but my answer to that would be very few. There would be no reason to, because the judge would go, well, that's what the FDA says, and they're there, right?
How about going forward, though, looking into the future a little bit? If this starts to get relied upon, would you see being more opportunity for M&A because you think you can go in, and if you're a bit bigger player, you've got more resources to change decisions, or is it still, that's a lot of work and time, so it's not worth it?
No, I think it'll take years. So I would say in 3 years or 5 years, we're going to know what the courts are doing with this, right? Your hope is, from a business perspective, is there's less limitations on technology because FDA's challenges there in terms of how that should be used and when it should be used are succeeding, right? Rationally, we hope. We don't, right, want rules abandoned that endanger patients. That's what we're suggesting, but rationally, right? So I think it'll increase, and I think it's a better opportunity for targets and people trying to build their portfolio in larger companies or private investment companies. All right, thank you.